Hello guys, once again, I'm Dibya Prakash. Today we'll be again talking about the bailment under the Indian Contracts Act. So let's get started. Firstly, bailment. So what is bailment? Bailment is mainly derived from French word bailer, which means to deliver. However, in the Indian law or in legal context, it refers to the contracts of goods which result a contract which results from the delivery of goods. And contract of bailment, only possession is passed on, not on passed on, and not the ownership, which means that there is no permanent transfer, or there is no transfer of ownership. That is, the good is still being held with the main person to who has transferred. It's just the transfer of the possession has been transferred. There cannot be a bailment of immovable property. Your house, your land cannot be bailed out. It has a different terminology that is called leasing the houses or the immovable properties, and generally there is no concept of bailment. Now, Section 148. What does Section 148 of the Indian Contracts Act say? Section 148 of the Indian Contracts Act says a bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The person to whom they are delivered is called the payee. Now we have to understand it clearly. A bailment is a delivery of goods. That is, a good has been delivered. Let's suppose a watch by one person to another for some purpose. So the purpose of the watch, Ram has given the watch to Sham for Sham to repair. Who's a watch repairer? Watchman. Next, upon a contract that they shall, when the purpose is accomplished, be returned. That is, when the watch is repaired, it is to be returned back to Ram, or otherwise disposed of according to the directions of the person delivering them. Or if Ram wants the watch to be sold off, then that is the direction of the person delivering them. The person to whom they're delivered is called the payee. That is, Sham is the bailee and Ram is the bailer, because Ram is the one who has given the property to watch to Sham. Examples: X delivers a piece of cloth to Y, who is a tailor. So X is the bailer here, delivers a piece of cloth to Y, who's a tailor, to be stitched into a suit. The purpose is to be stitched into a suit. This is a contract of bailment. Next is X delivers a watch to Y, as we just spoke of the example, a watch repairer for repair. Gold given to goldsmith to make ornaments. Something left with the friend inadvertently, that has been left for some purpose. When a person finds lost goods, implies a contract of bailment. How does it say that it's a contract of bailment? Because there has been just a transfer of the ownership. There is just transfer of the possession. That means the watch is still there. Is, let's say, a ring that's there and that has been found by Sham that belongs to Ram, and that ring now has to be given back to Ram by Sham. If not, that would be considered stealing. And there has been a good that has been found just to be returned, as it was mentioned. Now, what are the essentials of a bailment? First of all, a contract of bailment is a necessity because there's no purpose laid down, without which, if there is no bailment, then there has to be delivery of goods, delivery of possession of goods from one person to another. Note: mere custody of goods does not amount to changing possession. Goods must be handed over to the bailee for some purpose, as it has always been mentioned in Section 148 as well, that mere custody just for the purpose of having it doesn't mean bailment, but it must be handed over to the bailee for some purpose. The delivery of possession or the delivery of goods is of the following kinds. Firstly, actual delivery, that is when the goods are physically handed over to the bailee by the bailer. Second is constructive delivery, handling over the documents of a warehouse, or the keys of a warehouse, document of a title goods. Third is delivery of goods must be for some purpose. That is, it has to be, the goods must be for some purpose. That is example of a goldsmith making gold. Delivery upon a contract. There is no bailment where the delivery of goods is without contract. In a case of a minor as well, that there is no bailment where the delivery of good is without a contract. So if there is no contract that has been signed up, then there is no point, and then there will be no bailment or the concept that has existed. And the good has to be returned. Yes, the good that has been taken once, or it has to be disposed of in accordance to what the man says. That is, the bailier says. Now, some cases that are mentioned, Dr. R. K. Bangia, I would like people to take that under cognizance and read them properly. Jagdish Chandra Trikha versus PNB, Ulzin versus Nicole. It's a landmark case, please note. National Bank of Lahore versus Sohan Lal. Ram Gulam versus Government of UP. LM Cooperative Bank versus Prabhudas Hathibai. State of Gujarat versus Mahmood Muhammad. Hyman versus Nye and Sons. That's another important case. And Atal Mehra versus Bank of Maharashtra. So these are some cases that we can use for references and for understanding the concepts. It might be useful. However, it's just Hyman and Nye and Hyman versus Nye and Sons and Ulsen versus Nichols to be handled more carefully. Now, what are the kinds of bailment? Moving on the basis of benefit and on the basis of reward. So on the basis of benefit, we have exclusive for benefit for the bail of the bailer, exclusive for the benefit of the bailee. Now, what is the example of exclusive benefit of bailer? A has made gold, has given gold for making jewelries to B. Now B returns it. So what is the benefit? A gets the jewelry, he gets the purpose served, and B, for the benefit, he gets the money of the charge that has been made. There's a benefit. On the basis of reward. Gratuitous bailment, that means goods that are delivered by the bailiff to the bailee without any reward. That is lending book to a friend. Second is non-gratuitous bailment, where bailor and bailee is entitled to reward for bailment. As we said, card letter for hire, the bailor is getting the money and bailee is taking out the card for some purpose, etc. Gold given to the goldsmith for the making the jewelry with the charges. Now, what are the duties of bailee? First and foremost duty of the bailee is to take the reasonable care. As a prudent man, he would take care of his own goods. In similar lines, he has to take care of the goods that has been provided. If any loss or damage has been incurred to the goods of the bailee in spite of such due care, then he will not be liable for any such loss or damage. The burden of proof is on the bailee to show that he was not negligent. This was held in Union of India was Udharam and Sons. Next is, the bailee is not answerable for any loss to goods bailed caused by an act of God. That is very easy to say. That's in lightning or flood or an earthquake. For sure. This was held in Gopal Singh, Hira Singh versus Punjab National Bank. Now, what are the examples of the reasonable duty? So X bailed the goods to Y. In spite of Y's taking care of reasonable goods were stolen, and Y did not inform the owner or police. Y was held liable. Why? Because it was the responsibility. The goods that were stolen actually belonged to X. So Y should have responded, but Y did not. So Y was held liable. Now, X had a wooden shop and it was burst by mobs during a communal riot. It was held that he was not liable. Next, not to make any unauthorized use of goods. A lends a horse to B for his own riding only. B allows C, member of the family, to ride the horse. The horse accidentally falls and is injured, so B is liable to make the compensation. It's very clear from the example. Third is not to mix the goods with his own goods. Mixing with bailor's consent and then mixing without bailor's consent. Now, if there is a consent of the bailor, then there is no liability that has to be held. Then the bailor is aware of the fact. However, if it is mixed without bailor's consent, then he is liable and he has to pay off in accordance. But goods can be separated. Bailey is liable to bear all the expenses of separation. Now, how do we do that? Here's the example. A bails 100 bales of cotton marked with a particular mark to B. B, without A's consent, mixes the 100 bales with other bales of his own bearing a different mark. Now, A is entitled to have his 100 bales returned, and B is bound to bear all the expenses of the separation of the bales. This is clear from its own example. But the goods mixed cannot be separated. The bailor is entitled to be compensated by the bailee for the loss of goods. Not to set up adverse title, bailee must hold goods on behalf of and for the bailor, even he comes to know about the true owner of the goods. So it is an important thing that not to continue thinking that the property belongs to the person himself. Next, to return increase or profit. It happens in case of animals. A leaves a cow in the custody of B to be taken care of. The cow has a calf. B is bound to deliver the calf as well as the cow to A. Next, to return the goods. If he fails to do so, he becomes liable for any loss, responsible also for the act of God. Example, in the case of Shaw and Co. versus Simmons and Sons, X delivered books to Y to be bound. Y promised to return the books within a reasonable time. X pressed for the return of the books, but Y failed to deliver them back after the expiry of reasonable time. Subsequently, the books were burnt in an accidental fire at the premises of Y. Y was held liable for them. Another case that can be looked is J.K. Oil Mills versus Union of India. Now, where there are several joint owners of the goods bailed, the bailee may return the goods to any of the bailer. So supposedly there is a house. Let's take another example. Supposedly there's a car. Now the car is the name of three brothers. So when it has been lent out, so the bailee can return to any of the three brothers if required. But there is a gratuitous bailment. The bailee is bound to return the goods to the bailer on demand, even before the expiry of the fixed period or accomplishment of purpose. The bailer is liable to pay if there's any loss incurred due to the termination of bailment. For example, books for reading. What are the duties of the bailer? First of all, the duty of the bailer is to disclose the faults in the goods bailed, repay the necessary expenses in case of gratuitous bailment. Where the bailee is required to keep the goods for the benefit of the bailer without any remuneration, it is the duty of the bailer to repay all necessary expenses. Example, X leaves a horse in the custody of Y to be taken, and Y is to receive no remuneration. All expenses incidental therefore to feeding horse, medical expenses should be paid to Y. To repay the extraordinary expenses in case of non-gratuitous bailment, Y hires X's horse for his carriage. The horse becomes ill and Y spends ₹50 on medical expenses over and above ₹20 on feeding the horse. X is liable to pay Y ₹50 the extraordinary expenses only. To indemnify the bailee, next example, the bailer has to indemnify the loss if incurred on defective title of the goods. Fifth, to receive back the goods. If the bailer refuses to receive back the goods, he is liable to compensate the bailee for the necessary expenses of the custody. Now, what are the rights of the bailer? Right to claim for loss caused to the goods by the bailee for not taking reasonable care. Right to claim damages for mixing goods without consent. Right to claim increase in goods if there is an increase in the quantity of the goods that have been bailed. Right to demand back goods. What are the rights of the bailee? Right to recover extraordinary expenses incurred on goods. Right to claim damages incurred because of non-disclosure of faults in goods bailed. Right to deliver goods to any one of the several joint owners. Right to receive compensation for loss incurred for bailer's defective title. So what are the bailee's lien? What is the meaning of lien? And then we'll answer. Lien is the right of a person to retain the property or goods of another until he pays the lawful charges or debt due upon. The right of lien is lost when possession is lost. The right of lien extends only to the possession of goods and is not to right of sale. Section 170 and Section 171 deal with the right of lien on bailee's goods. Types of bailee's lien. Particular lien. Section 170. A retention of particular goods in respect of which some charge is due. A delivers a rough diamond to B, a jeweler, to be cut and polished, which is accordingly done. B is entitled to retain the stone till he is paid for the services he has rendered. This was held in Irulji versus Café Rose in 1943. Now, what is general lien? It entitles the person to hold goods of another for any amount due to him, whether in respect of those goods or any other. This has been conferred only to the following kinds of bailees: A. Bankers, B. Factors and factor owners, brokers, wharfingers, and attorneys at High Court. Now, what are the conditions to be satisfied? The bailee must have rendered some services and must have been entitled to some remuneration for it. The service must have been performed in full, no lien if part performance is done. The bailer cannot exercise the right of lien where he has agreed to render services on credit until the expiry of the period of credit. The goods must be in possession of the bailee. If the possession is lost, the lien is lost. Now, possession of finder of goods. Section 168 allows the finder to retain the goods against the owner until he receives compensation for trouble and expense. Further, where the owner has offered to pay a specific reward for the return of the goods lost, the finder may sue for reward and may retain the goods until he receives it. What is the best example? A dog is lost, 50,000 rupees to be paid, the person is found, and now till the time the 50,000 is paid, the dog shall remain in the possession of the retained. Question, section 169. When the finder of a thing commonly on sale may sell it. Section 169 says, when a thing which is commonly the subject of sale is lost, if the owner cannot with reasonable diligence be found, or if he refuses to upon demand to pay the lawful charges, the finder may sell it. A. When the thing is in danger of perishing or of loss of greater part of its value. The lawful charges of finder respects in thing found, and if it is found and not paid off, then in that case as well. Now, what are the termination of lien? Agreement between parties, payment of debt, loss of possession, refusal of tender by the bailment. Termination of bailment. On the expiry of the period, the bailment is generally meant for a specific period till the time the benefit is there. Accomplishment of purpose. Practices bailment in between whenever it is needed because there is no exact remuneration that is required. Death of the bailiff or the bailey. At that point, it ends. Thank you very much and have a great time.